The underlying principle for actions in the UPC is open justice. This means that within certain limits of confidentiality protection, proceedings and decisions of the court are open to public view. Indeed, the rules confirm that decisions and orders from the divisions of the UPC will be published on the UPC website for public access, with redactions only where necessary. However, controversially, the rules were changed last September to say that pleadings and evidence can only be obtained by a reasoned request made to the UPC registry. These requests will be decided by a judge rapporteur following consultation with the parties. However, a third party can still make an application to the court should access be refused by the judge rapporteur. Ultimately, this means that dissemination of pleadings and evidence can be prevented by a party to those proceedings seeking to protect confidentiality. As between the parties, there's also a specific right to apply to have information restricted to certain persons, in effect setting up confidentiality clubs, which will be familiar from English litigation. The details of the approach taken to confidentiality clubs will have to be determined, but this may prove to be contentious if the UK proceedings have anything to go by. A related issue is privilege, which will be relevant to the disclosure of documents and preparation of expert reports. The UPC rules of procedure are based on the English rules of client-attorney privilege and litigation privilege. However, there are no detailed rules on what is and isn't privileged, and these are not concepts used by the civil courts on the continent. So without the experience of English judges in the UPC on questions of privilege, there is some uncertainty about how privilege will be applied in the UPC.